Good afternoon and welcome to The Law. On this edition, we are looking at the Constitution Review Committee's report. The 128-page report of the Professor H. Kwesi Prempeh-led Constitution Review Committee. This report is the report of the recommendations. That has to be distinguished. So it is not the full report. It is the report of the recommendations as finalized by the committee and submitted to President John Dramani Mahama. We'll be right back to get into the details. It is not a report that speaks only to extending the presidential term to 5 years, reducing the minimum age for a presidential hopeful, to 30 years from 40 years. It has more than that. I'm Samson Ladianyenini. This is The Law. It's your legal light. It is your help law. You're welcome back. So Ghana has been at a process. It's been a journey of the process of trying to amend, review, change, whatever, the 1992 Constitution of the Republic of Ghana, because we believe that there's been some obsolescence, that for all the period of time since 1992 or 1993, so to speak, the portions of the Constitution may have become obsolete. Some of the provisions may have outlived their usefulness. Some of them need improving. After all, the unexamined life is not worth living. So, beginning with President John Evans Fifi Atta Mills, the journey began to review the 1992 Constitution of the Republic of Ghana. So a Constitution Review Commission of Inquiry instrument of 2010 was made in 2010. And it appointed the following persons as the committee members. You had Professor Albert K. Fiajo, Professor Emeritus of Public Law, as the chairperson. Osaberima Kwesi Atta, Paramount Chief of Cape Coast, was a member. Na Idrisu Abu, Kumbung Na, Paramount Chief of Kumbungu, was a member. Mr. Akenton Apia Menka, lawyer and industrialist, was a member. Mrs. Sabina Ofori Boateng, consultant to the Legislative Drafting Unit, Office of Parliament, was a member. The Very Reverend Professor Samuel K. Ejepong, President, Methodist University College, Ghana, Chairperson, African Peer Review Mechanism Governing Council, was also a member. And remember, the African Peer Review Mechanism was an instrumental part for the need for a constitution review as they dealt with governments and presidents across the world, including President John Ejekun Kufuor, who committed this country to the need to reviewing the Constitution, but never got to start it. And so when President John Evans Atta Mills came in, he began the process. That was me digressing. Dr. Nicholas Amponsa, Senior Lecturer, Department of Political Science, University of Ghana, was also a member. Mr. Gabriel Poaman, that's Scott Poaman, legal practitioner. He's now a Justice of the Supreme Court of Ghana. He was a member. Mrs. Jean Mensah, Executive Director, Institute of Economic Affairs, IEA, Now, the chairperson of the Electoral Commission of Ghana was also a member. So that is the membership, the chairperson and the membership of the first attempt at a holistic review of the Constitution 1992. And those were the chairperson and the members. They produced a 1,000-page report, a 1,000-page report detailing why it was necessary to amend various portions of the Constitution. Now, in 2024, another committee also was set up to do some work. That is under President Akufo-Addo. This time, that committee was not set up by the president. Remember, in 2010, the committee was set up by President John Evans Atta Mills, and John Mahama inherited their work. When they presented their report in 2012, work could not be done. There was a legal suit. There was a suit in the Supreme Court against their work. Even though an implementation committee had also been set up, that suit eventually was concluded sometime by 2015 or 16 thereabouts, or November, sometime thereabouts. And eventually, as you know it, President Mahama was removed from office, so they couldn't continue that project. Now, in President Akufo-Addo's time, Osei Che Mensah Bonsu, the majority leader and leader of government business, he was the one who, under his Ministry of Parliamentary Affairs, also set up a committee to review the Constitution. That committee was not called the Constitution Review Commission. It was called the Constitution Review Consultative Committee. Who were the members? Clara Kolega Berry Kasati was a chairperson. This committee was institutionally represented, and Clara came from the University of Ghana School of Law, having been nominated through the Dean of Students. Then you had Victor Brobe, National Commission on Civic Education. Professor John Asafo-Adjei, African Center for Economic Transformation. Twenebua Kodia Dixon, Ministry of Parliamentary Affairs. Yabwedu Ayeboafo, National Media Commission. Justice Yoni Kolendi, Emmanuel Yoni Kolendi, representing the judiciary. John Iwoza, representing the Audit Service. Anthony Forsing Jr., representing the Ghana Bar Association, former president of the Ghana Bar Association. Alfred Tuah-Yeboah, Ministry of Justice and Attorney General's Department. He was a deputy minister for Justice and Attorney General. Mercy Labi, representing the Commission on Human Rights and Administrative Justice. Dr. Kojo Mensah Abrampa, deceased, substituted by William Dochi Asari, represented the National Development Planning Committee, and Nana Tewia Ochri, Parliamentary Service. So the Clara Berry Kasati Committee is what I just mentioned to you. They too finished their work and submitted their report in December of 2024 to President Nana Addo Dankwa Akufo-Addo. They had a report of 248 of work. And then power changed again when we went to the elections. And John Mahama was re-elected. When John Mahama was re-elected, then the Professor H. Kwesi Prempeh Committee was brought into being. That's the committee you are seeing in your shot right now. The Professor H. Prempeh Committee. He is the chair of the committee with Dr. Rena Akumperia, a lawyer who is secretary to the committee. Professor Raymond Atuguba used to be the secretary to the Constitution Review Commission, Professor Fiajo's committee. Justice Sophia O.A. Adinyira is a member. Charlotte A. Kesson Smith Osei, former EC boss, also a member. Dr. A.C. Ansa, a lecturer at Ashesi University, also a member. Professor Kwame Karekari, a colossus in media affairs, so to speak, in journalism, is a member. He's also a teacher at the University of Ghana. Alhaji Ibrahim Tanko Amidu, also a member, Star Ghana, that's correct. Dr. Godwin Jokoto is also a member. He's a lawyer and teaches law at the University of Ghana. So that is the Professor H. Kwesi Prempeh Committee, set up by John Dramani Mahama. What was their job? They too were given the same assignment to review the 1992 Constitution. But the assignment was sort of cut out for them. In what terms? The terms of reference that was handed them was that they should look at the 2012 report by Professor Albert Fiajo. They should also look at the Claraberry Cassity report, the committee set up by Che Mensah Bonsu, who also submitted their report to the president. So they were also to look at these two reports and then also engage Ghanaians to determine radical recommendations. That's what President Mahama asked of them, that they should bring recommendations that are radical to changing the constitution. And they set out to do their work. They have submitted the report, which I referred to a while ago, of 100 plus pages. That's 128. You have read about the highlights. We have decided here at the law to give you the opportunity to get to know the raw details of the report, rather than the few portions of it, handful of the portions that is in the public and dominating the entire report. So welcome. Now, let's begin to go through some of the proposals or recommendations that the H. Kwesi Prempeh Committee has made. Some you have become aware already. That's part one of this presentation. And then we'll continue to share with you many of the things they have sought a recommended change that you are not aware about because you have not read and the media has not paid attention to them. Now let's begin with some of those that you're already familiar with. Here on your screens, you're seeing, just informing you once again that the committee was set up and officially sworn into office on January 30 to formally start work. The committee submitted its report on December 22 after nearly 11 months of work. Initially, it was thought that they would use about 3-6 months to work. They discovered that was not workable. So the committee, among others, has recommended appropriate amendments to Article 88. Article 88 is about who? It's about the Attorney General. To amend portions of Article 88 of the 1992 Constitution to take away the Attorney General's authority to prosecute corruption and corruption-related offenses, and SHRAJ's corruption investigation powers. SHRAJ, as set up, has an anti-corruption aspect. So those are being taken away from SHRAJ, and then the Attorney General also prosecutes corruption matters. Those the proposal is that take away those from the Attorney General as well. Now they are seeking to vest all authority for prosecuting corruption. Remember, it's corruption, not all cases. Corruption in a proposed independent anti-corruption and ethics commission. Independent anti-corruption and ethics commission. That commission will take over and also merge with the legislatively established Office of Special Prosecutor to create a one-stop shop for all corruption and corruption-related prosecutions. So as we speak now, the Office of Special Prosecutor, OSP, is the country's sole body vested with the prosecution of corruption as a lead body, not the sole. IOCO used to prosecute corruption. Those powers to prosecute corruption have been taken away from IOCO and given to the OSP. The SHRAJ also still does some corruption issues, but it doesn't prosecute. The Attorney General retains power to prosecute matters including corruption. The proposal is that you set up an all-purpose, body, which is an independent ethics and anti-corruption commission that will do that job. So OSP will not be there anymore. It would have found itself melted and merged and submerged into the one-stop shop of the commission. Independent Ethics and Anti-Corruption Commission. So any person who has aggrieved may submit a confidential petition for the removal of the Chief Justice to the Council of State. That's what they are proposing now. Under the current regime, if you want to remove a Chief Justice, the way to go about it is to take a petition to the President. The proposal now is that take a petition, but to the Council of State, not to the President. In fact, the appointment of the Chief Justice, they have also tweaked that. Now they are proposing that the appointment process should go through a short list of two or three people through the Judicial Council to be sieved, and then a list of the two, at least, or three qualified submitted to the President for the President to pick from for the purposes of the appointment. And when the Chief Justice is appointed, through a publicly advertised process, the Chief Justice will be in office for 10 years non-renewable, 10 years. But if you're appointed to be Chief Justice and you hit the age 70, then you will have to retire. But if you are not, then you can be there for up to 10 years. Let me go back. Let's go back to, yes. So now if you want to remove the Chief Justice, you take a petition to the Council of State rather than the President. And formally, when you take the petition to the President, there are no timelines. The President can keep the petition forever. The President can decide when he forwards the petition or works on the petition. Now, there is no that option. Within 7 days of receipt of the petition, the Council of State is supposed to refer the petition to its judicial committee to determine a prima facie merit, if it has merit. Usually, currently, is the President doing so with the Council of State. But now, is the Council of State that will do the prima facie determination. And once the prima facie determination is made, a committee is supposed to be set up by the Council of State. And check this. Instead of the President or the Council of State being involved in that constitution of whichever committee, now the President and the Speaker of Parliament are involved. The President will appoint one lawyer. The Speaker will appoint one former member of Parliament who is not serving as an officer of a party. Then the National House of Chiefs, correct, will also appoint one. It's a 5-member and institutional appointment, so that the Chief Justice removal process is a bit sacrosanct. The President then may suspend the Chief Justice pending the investigations. The Council of State shall then, I've mentioned that 5-member tribunal, the tribunal shall conduct its hearings in camera, not in public, and submit its findings within 60 days. We didn't used to have this. We only had timelines for the removal of the special prosecutor or the deputy. Now, this is rather good. Establishment of independent registrar and regulator of political parties and campaigns. We realize that the campaigns, how it goes on in the political parties and how they conduct themselves, we need a certain independent body rather than the Electoral Commission to do that job. So an IRRPC will be appointed. It will take over the EC's powers and functions in governing political parties and campaigns. Remember, governing political parties and campaigns is not the entire EC's work. They will appoint a democracy fund supporting policy development, gender inclusion, and non-campaign activities. So there's been the campaign for state funding of political parties. They will find a way to get money. Let's go to the next slide, to support parties to survive and do what they have to do. They will limit campaigning days to a fixed period of 120 days, for example, before general elections. In Ghana today, once John Mahama was sworn in or was voted into office, the opposition NPP began its campaign and has been campaigning throughout until 2028. Elsewhere, that is not how it is done. There are campaign periods. There are periods when you don't campaign, so that we all focus on national development. That's the sort of thing that we want to have in Ghana. I'm privileged to belong to a committee that is working on national ethics and anti-corruption action plan that has also proposed a similar thing, a fixed campaign period of campaign season. What you have heard about as the government WhatsApp group. Yeah, funny. Restrict the amount and kind of expenditure a political party or candidate may incur in a campaign. They will require approval of fees charged by the parties as aspirants and candidates in primaries. You know, the monetization of our, elections. They'll have to do something about it. Mandatory disclosure and audit of campaign finances of political parties. This already exists somewhat, and it is the Electoral Commission that is supposed to do it, but we have discovered that the Electoral Commission doesn't seem to have time to do these things. A lot of the corruption in the country is as a result of campaign financing. So now, if this is adopted and passed into the next constitution, where you get your money to campaign, all of us will get to know how much you are spending. We'll get to know about it. Next, the EC commissioners and their deputies shall hold office for a single 10-year term, just like the Chief Justice. This is the same thing for the Electoral Commission, chairperson and deputies. But in their case, if they reach 65, I think, before 10 years reaches, then they will definitely have to resign. You can't do 10 years simply because the law says 10 years. There may be resignation or your tenure may be stopped by the years you have retirement age, so to speak. In that regard, the Fiajo Commission had proposed 7 years, but this committee is proposing 10 years. Reduce the number of the deputy commissioners from 4 to 2. Yes, so now they will have only 2 deputies. EC should publish the procedure for dealing with death of a presidential candidate. because we do not have that procedure yet. Next, retain the 2-term limit for the president, but extend the presidential and MP term to 5 years. This is what has become so popular, everybody is talking about. So presently, the president, according to the 1992 Constitution, serves a 2-term, potential 2 terms of an 8-year tenure. 4 years, if you're lucky, you get re-elected, you serve another 4 years. The proposal is that let's move it to 5 years. If you're lucky, you get voted, you do another 5 years. So cumulatively, you do a total of 10 years. Why? Because this is also becoming the trend elsewhere, where they are doing 5 years instead of 4 years. And again, because we have been told that elections, the 4 years, they spend almost 1 year getting ready to set up the government, and the final year, they almost spend it doing campaign and they don't focus on developing the country. Lower the minimum presidential age from 40 to 30 years. People are also talking about this. In fact, those who submitted the proposals wanted it to go to about 20 years or 21 years, but they decided on 30 years. Subject the president to taxation, including indirect taxes, like all citizens, right? President must pay tax. Create an independent public emoluments commission to determine salaries and benefits. Instead of the Article 71, the ex gratia that they take so much money that we are unhappy about, there should be an emoluments, committee or commission to deal with that. This was actually proposed by the Professor Fiajo Committee, set up in 2010, and the Claraberi-Kaseti Committee, also set up in 2024. Retain the 2-term, so we move on. Limit the post-presidency immunity, allowing civil actions anytime and criminal actions within 4 years after leaving office. So presently, if you have a president, during their term as president, you can't take a suit against them. You can't take them anywhere in any court in Ghana because we want to give them the peace of mind to work. But the law has been made such that once they leave office, we give them a little room, about 2 years thereabout, and then once the time expires, 2 to 3 years, you can't take them on again, regardless of what they have done. Now, this committee says, let's extend that period to 4 years, so that even when they leave office, within a period of 4 years, there should not be expiration to the wrongs they may have done. Once we discover them within the period of 4 years, we should be able to take them on and not say that you have left office after 2 years or after 3 years, we can't chase you anymore because we didn't bring any suit against you. And even so, it says remove the immunity, allowing civil actions any time and criminal actions within 4 years. So whilst you have left office, we can limit that within a period for civil actions, and then for criminal actions within 4 years. Decouple ministers from parliament. MPs cannot be appointed ministers or deputy ministers. This was also proposed by the Claraberi Committee. The Fiajo Committee said, allow the president the free hand to determine where he wants to appoint his ministers from. But this committee says no MP should be minister. No minister should be MP. And if you want an election to be in parliament and you decided to resign so you can take office as a minister, you will not be allowed unless that 4 years or 5 years, if we get it, has elapsed, then you can become a minister. Cap the size of government at a minimum of 57 ministers, including deputies and regional ministers. So this is what it's going to look like if we adopt it. Deepen political and fiscal decentralization, including the election of MMDCEs. This was also proposed by the Professor Fiajo Committee, but the white paper, tried to vary it. And the Clarabelle Committee also proposed election, not on partisan basis, as has been supported largely by members of the public. But this committee now says, let them be elected, not on partisan basis, but let's look at the places where, the district or the municipal is big enough to do elections, and then let's set a certain criteria so that those who want to also elect their MMDCs, they can gradually get to that stage, not free for all the districts and municipal assemblies. Make censure binding. A censured minister must be dismissed and cannot be reappointed during the same term. Presently, if a minister does something wrong, Parliament can censure that minister. But when they censure that minister, the president has the ultimate decision to take, whether to remove or dismiss that minister or not. So you can censure the minister, but the president can decide that, go to hell with what you think. I want that minister. It can be a Ken Oforiatta and all the people who pass a vote of censure against him, and still, nobody will do anything, even though his own didn't succeed. But now, the committee says, once Parliament passes a vote of no confidence in a minister, the president is bound to remove that minister. Just like when a committee probing a chief justice or a justice of the Superior Court finish their report, the president is bound to follow their recommendations. Reform public appointments by classifying offices as executive, independent, or hybrid, and bind the president to advisory role. Restrict presidential powers during post-election transition period. Shift presidential elections to November to allow a longer transition period. This has been in the works for a long time, so that even in President Mahama's time, they tried to pass a bill to make that possible, so that we have elections in November rather than in December, so that it can be a transition and then we have sufficient time for the transition. Elsewhere, that's how it happens. Here, we go to the elections and then within what time? Very short time, we are supposed to swear in a president. It's too short. Cap Parliament at 276 MPs and reform constituency demarcation to prevent apportionment. The Clarabelle Committee also said cap Parliament, because all of them can't seem to say, let's reduce the number of MPs because they have abused it through gerrymandering and giving us too many MPs, 276, too much for a small country like ours. So they say, once we have gotten there, let's stay there. Let's not move beyond that period anymore. There are some people who are not happy about this because they wanted also a different form of elections of MPs into Parliament. Strengthening parliamentary independence by allowing caucuses to elect and remove their own leaders. You know how the parties have been intruding into Parliament's work in this regard. Allow dual citizens by birth to contest parliamentary elections. In 1998, was it? We did something about this, and that has become a big problem for dual nationals. And so we are seeking to remove that barricade and allow Ghanaians who are nationals of other countries, but who are citizens of Ghana by birth, to contest for parliamentary elections. Professor Kweku Azan will be so excited about this. Require public officers to resign with a cooling off period before contesting elections. Right. Require open and recorded votes on constitutional amendment bills. In our parliament, they vote and nobody knows how they vote on any issue. So at least when it comes to constitutional amendment bills to amend the constitution, we should know that Kojo Oppong Nkrumah voted against it or voted for it for his constituency, Ayerebi of Fuatse, and we should check if the constituents agree with him or they disagree with him? Is it possible that he had a meeting with his constituents and they said that we don't want this, and he went and decided to do his own? Or he went and his party said, this is what the party wants, and he went against his constituents and did something different? So we must record your vote and know how you voted. We're going to be voting sometime maybe on LGBT. That's not a constitution amendment bill, right? But perhaps things like that. We get to know where you stood, so that in future, if you say something, we can show you that you were here. Curb abuses of the certificate of emergency urgency with strict safeguards. How some legislation, very important legislation, before you know it, they say certificate of urgency, they have passed it. No, give opportunity for people to participate in the process. Constitutionally guarantee public participation in lawmaking, strengthen conflict of interest rules, and replace MPs' gratuities with a pension scheme. Well, we are all on a pension scheme, is it not? MPs too, they should get on a pension scheme rather than getting a different sort of treatment. Strengthen the independence, funding, and mandate of the NCCE and NMC. Also, NCCE, give them a 10-year appointment, non-renewable, 1 year, 10-year, and if they reach retirement, they should go, but if they don't, they should stay until then, or unless a removal process or a resignation or death, they leave office. These are some of the popular stuff you already know, but a good number of this I know have not been that popular. You haven't known about them since the committee submitted its report. We'll be right back to share with you some more of those recommendations that are not so popular but important. We are going through the recommendations report with you. That's all. Welcome back. This is The Law. It's your legal light. It is your help law. So what we have just done here at The Law is simply take upon us the duty to help you because you don't have time to go through the whole report of the Constitution Review Committee's recommendations report. Remember, it's not the full report. The full report will be bulky. Maybe perhaps like the Fiajo report, which was 1,000 pages. The Parliamentary Committee report, 248 pages. And even that they try to, as it were, be brief and straighten up things. This one, they have submitted the recommendations only to the president. So it's the recommendations we are going through. Now, some of the other things that people don't seem too interested and have not gone about them. So let's try and share with you. Now there is going to be something very remarkable to be done with the Constitution, because amending the Constitution has become a problem. A regime may want to amend the Constitution, but if they don't get the support of the opposition, it's almost impossible to amend the Constitution, particularly the entrenched provisions, which require a referendum. All right? So, you remember President Akufo-Addo wanted us to amend the provisions to elect MMDCEs. The agreement going into that was for an amendment to allow MMDCEs to be elected on non-partisan basis, as done elsewhere. But the president decided to dilute it and said, let's amend and elect them on partisan basis. Eesh. So, I confess, as you know, I started a campaign against it, and I got an overwhelming support. And the president did what people say like a kid. He said, the ball is mine. I brought it for us to play on the field. If you are misbehaving, I take my ball back. So he rescinded the process. We never went to the referendum for it because it was going to lose big time. And the campaign was good. Right. Now, because of that problem, elsewhere there's something that happens. Like in Kenya, if you want to amend the Constitution, it can be amended through a popular initiative. It shouldn't be by a president initiating it. In fact, when the president initiated the 2010 process, Professor Kukwasari went to the Supreme Court and said, President cannot do this. Well, the Supreme Court confirmed that the president can do it. In Akufo-Addo's time, it was a Minister of Parliamentary Affairs, Osei Mensa Bosu, who set up the Parliamentary Committee. all of these can bring problems and parties can hijack it and do a few things. So they say, to cure some of these problems and give people the opportunity, let's have what you call the popular initiative in constitutional amendment. Citizens should be able to propose changes to the constitution if at least they got 5% of registered voters nationwide to endorse the idea through physical or verified digital signatures, after which parliaments must table it, give public notice, hold mandatory consultations, and then decide to adopt, amend, or reject it, requiring approval by at least 75% of MPs for what is, they have now also done something about the, amendment clauses, a chapter of the Constitution, semi-entrenched provisions, and 2/3 for non-entrenched ones, with Parliament also mandated to pass laws ensuring public participation throughout the process. You can find this at page 127 of the report. Now, okay, so time is actually running out. They also say we should give some period, make a law, so that maybe every 10 years, maybe every 20 years, then the Constitution is up for amendment for certain portions of it. Then also the problem of constitutional obsolescence. Parliament should be required to pass a law that ensures that Constitution is reviewed every 10 to 25 years. It's 20 to 25 years. I said 10 earlier, no. 20 to 25 years after we have lived the Constitution, there will be the need to review it. So you can review that by an appropriate body with mandatory public participation and published report so that the Constitution keeps pace with changing social needs and expectations. Still, at page 127, you will find this. Chieftaincy and traditional authority. Exclusion of chiefs from active party politics. So the committee recommends keeping Article 278, which bars chiefs and queen mothers from endorsing candidates or political parties while allowing them to express support for policies or projects, and further proposes that violations be reported to the National House of Chiefs, which must establish and publish a clear process for handling such complaints. If you go to page 121 of the report, you will find it there. Presently, chiefs are barred from active party politics. In fact, somebody went to court, and the court, through a lucid, very great, decision by Justice Yoni Kolende, endorsed that chiefs cannot do the things they do, but they can support policy or projects of a government, because chiefs are development agents. But when the chiefs break this part of the Constitution, what happens to them? Like Professor Kwekwaza will say, parts of our Constitution is just suggestions. If you break it, you hardly suffer anything. So now, if you are a chief, if we implement this and you are a chief, and you violate the exclusion from active partisan politics, you violate it and you go into partisan politics, somebody can make a complaint to the National House of Chiefs, and they'll go through a process of punishing you, the chiefs. Also, they have some things to say about our rights and fundamental human rights. Now, there's a right to health. The committee proposes constitutional amendments to make health rights fully enforceable, guaranteeing every person access to essential healthcare services, including emergency care, maternal and child health, reproductive health, medicines, and preventive services, with no one denied urgent treatment for inability to pay or other non-medical reasons. Did you hear that? With no one denied urgent treatment for inability to pay or other non-medical reasons. The state must immediately provide emergency and minimum core services, progressively expand universal health care through legislation, financing, infrastructure, and workforce planning. And Parliament must ensure oversight and accountability, whilst courts are empowered to grant remedies without time limits, ensuring violation of health rights can be challenged and corrected to protect life, dignity, equality, and justice. In pages 110 to 112, you find this there. Why is this important? Because you know that in our Constitution, we have a provision that provides for all of us to do certain things right? Unfortunately, those provisions have been deemed, some of them, they have been deemed not to be enforceable in the courts. You can't go to court and say, the Constitution says we must do this. We must ensure gender balance. You can't go to court to say that the Constitution says we must ensure regional balance in appointments and so on. The president has not done it, so I have come to court. Those directive principles of state policy, which have been deemed not to be justiciable, they are providing clearly to make them justiciable, so that if the state doesn't take care of your healthcare needs, when you don't have money for basic things of health, and you cannot pay to cater for yourself, the state must do it. If the state doesn't do it, you can go to court, and the court will hold that you should be taken care of. Women's rights. The committee recommends constitutional amendments to Articles 17, 27, 35, and 36 to strengthen gender equality. Article 27 should be revised to remove stereotypical caregiving language and guarantee women's autonomy, bodily integrity, economic independence, and full participation in public life, while obligating the state to prevent and respond to gender-based violence. Article 17 should explicitly support affirmative action for women in politics, education, employment, and the public appointments. And Article 33, 35, 6 should make gender balance in public office binding, gender balance. It must become binding with no more than 2/3 of appointees from the same gender. And Article 36 should require the state to secure women's equal access to land, credit, inheritance, jobs, and entrepreneurship, with policies protecting women in informal and vulnerable labor sectors. We should pay attention to these aspects of the report. They are very important. We decided in 2020 to pass a Lands Act to try and give women some equality in ownership of property and land matters. But let's write it into the Constitution, because the Constitution overrides all others. Right, so that's what they are proposing. Fair trial. The committee recommends amending Article 19 to guarantee that criminal cases are investigated, prosecuted, and determined within strict timelines set by Parliament, ensuring trial happens within a reasonable period. If delays occur without the fault of the accused, courts must provide remedies such as dismissing the charges, excluding evidence, or reducing sentences, and any public officer who unjustifiably causes such unconstitutional delays should face personal liability, disciplinary action, and other legal consequences. Page 100, you will find this too there. And I love this because it was part of the things that I went to the committee privilege and I spoke about, because we live in a country where a trial can take, a trial in this country, not even criminal, civil matter, has taken 40 odd years. And Justice Georgina Wood described that as parody of justice. Criminal cases can linger on forever. When the NPP came into office, the Opuni trials, they were on forever to the end of the life of that government, all right? And then the Attorney General came in. Most of those people, they have been let go. They've been freed. So there should be timelines, timelines. If you take a person and you charge them, Parliament should set timelines and say, this trial must not go beyond 1 year, 2 years. The same way we have set timelines for presidential election petitions, right? We didn't used to have timelines, so we did it for 8 odd months in 2012. In 2021, because we set timelines and we said you can't do it beyond 45 days, we did it within that period. The same thing should happen. It happens elsewhere. You don't do a parliamentary election petition till the end of the life of that parliament, and later the court says the person who was aggrieved is the right person to be in parliament. Yet, the one who was wrongly put in parliament has already done all the years. They want the same kind of thing to be for criminal trials. There are people in jail. There are people in prison. They are on remand prison. Remandees. They have not been heard They have not been convicted, but they have been in jail for 20 years. Meanwhile, even if they go through the trial and they are convicted, maybe the crime they committed will not attract 20 years. What kind of thing is this? So they say, let there be timelines for criminal trials so that you do it and end it greatly. Retiring age, Article 199. The committee recommends amending Article 199 to remove the fixed constitutional retiring age and instead allow Parliament to set retirement ages for public service through legislation, with flexibility to adjust upwards for specific occupational groups, such as tertiary education staff and persons with disabilities, but ensuring that no appointed public officer retires later than 70 years. Page 90, you will see that. No appointed officer should retire later than 70 years. Those in the Superior Court, some High Court, Court of Appeal, 65 years. Then Supreme Court, 70 years. Now they're giving the Chief Justice 10 years. If he reaches 70, he should go. Electoral Commission, they are doing some of those things, and so on. So there are several things that we need to pay attention in the Constitution Review Committee's report. We will find time and continue to look at those things that may not be so popular and have not gotten media attention, but are very important to our life as a country, as recommended by the committee. And then we'll find time to discuss the pros and cons. It is not just about extending the presidential term to 5 years and reducing the presidential qualification minimum age to 30 instead of 40 years. There's a lot more. I will urge you to find time and read the report for yourself. This has been The Law. It's your legal lights. It is your help law. I'm Samson Ladia Yanini. Have a good afternoon.